Good afternoon, everyone. Welcome back to Business Law 2. Today we're going to be looking at Chapter 23 in our textbook, which involves the nature and regulation of real estate and the environment. So some of the overall learning objectives that I hope we can kind of take away after completing this chapter. First, understand the different types of interests that exist in real property. We'll look at the various rights that come with ownership of real property. We'll discuss a little bit in terms of easements, how they're created, how they function, and how ownership of real property is regulated by tort law, by agreement, and by public interest through what is called eminent domain. So those are the overall things that we're going to be discussing in Chapter 33 today. So when we talk about the nature of real property, under common law in the United States, the law has kind of distinguished or separated interest in real property in regards to two main categories. So we have freeholds versus leaseholds. So when we talk about a freehold, that's an interest in land that has kind of like an indefinite or an uncertain duration. So it is just an outright ownership or merely life of the possessor. So, when we think of your traditional type of ownership in land, leasehold is an interest in land that just has a termination date. So, owning versus leasing. So that's one way to kind of contrast, interest in real property. The other way in which to categorize interest in property is by either the time element of interest. So is it a current ownership interest or is it a potentially future ownership interest? And that's where you have present versus future interest states. So present interest is one that someone is currently owning and they're currently enjoying their property. And so that could be like a fee simple absolute. That usually is considered the most traditional and strongest form of property ownership. So you just own that property outright. Another form of a present interest is what's called a fee simple defeasible. And that's where you have ownership, but it's maybe contingent on a particular use. So there's something that is maybe inherent with the property. It could be folded as part of like a zoning thing, but usually there's a dedicated purpose. And so you're going to be limited in the type of use that you're able to kind of enjoy with that property. Another type of present interest is what's called a life estate. And so this is where someone is being benefited by being allowed to kind of not own, but to actually to possess the property for the duration of their life. They don't have an ownership interest, so they can't sell, they can't borrow against the property if you have a life estate, but you are able to kind of use and possess the property. And then either if you relinquish it or upon your passing, then at that point it reverts to whoever it belongs to. It could go back to the grantor of the life estate. It could be part of like an overall will or maybe a trust. Then it gets transferred to to like an heir of the decedent. In terms of life estate, there are some formalities that have to be followed, but it is possible to say, I will let you use this property. It could be a house, anything, that's titled to real property, but it's only for that lifespan of that person or until they relinquish it. Future interest is one that will come into the owner's possession upon the occurrence of an event. So it could be what's called a reversion, and so that's an estate that's transferred that has a duration less than originally by the owner and the transfer. So that's that life estate example. Maybe the grantor gets it back at some future point. There's also what's known under future interest as remainder, and that's where the reversion is going to a party different than the grantor. And again, like that life estate example, maybe I give you a life estate for as long as you want it or until you pass, and then once you're finished with it, then I'm going to give it to someone else in terms of just an outright transfer at that point. So that would be maybe like a remainder. In terms of rights incident to possession and ownership of real estate, so when we talk about airspace, I remember kind of growing up, my dad, who was in real estate, would talk about you own the land to the core of the earth until like up into outer space, and the standard that kind of has evolved over time is that you cannot violate adjacent property owners' airspace with structures, in terms of like the viewable area. Um, Regarding aircraft, the courts try and balance the right to travel versus the harm of the enjoyment of property. Sometimes there's what's called coming to the nuisance, and I've seen this in a variety of cases. This involves airspace, but it also involves other aspects of the enjoyment of property, where there is some nuisance type activity. It could be an airport. It could be like a large, type of like ranch or farm that produces a lot of maybe odors. And initially they're on their own. They're maybe miles away from any type of residential development. But then over time, residential development creeps towards the nuisance, and usually, I've seen this kind of play out in different ways. Normally, you kind of, if you decide that you're going to, build a development and sell residential homes adjacent to, let's say, an airport, part of understanding the value of that land is that there's going to be a nuisance in terms of things that you hear in terms of plane activity. If it involves smells, the same kind of concept applies. Although I have seen situations where the individuals that come to the nuisance actually kind of compel the nuisance to relocate. But so I've seen it kind of happen in both cases. But usually the idea is that if you come to a nuisance, you're kind of owning that. So anyway, in terms of depths, so again, going down below the surface of the land, rights vary from state to state. Generally, resources below the surface of the land belong to the landowner. It can be severed and kind of sold, distinct from the property itself. So let's say you discover, this weekend that you have oil in your backyard. So it's like, you have an oil, like, kind of like deposit. It is possible for you to kind of segregate or separate that from your land ownership, so that you could go to a company that extracts oil and say, look, I will contract with you. You'll pay me either a flat fee or maybe so much per barrel that you extract from my land, and I still own my property though. So, and that includes other resources, minerals, diamond mines, all kinds of things that you could imagine. Um, Currently, out west, there is an issue regarding water rights in terms of like the water table, water that is under the ground. There are a lot of companies right now that are trying to buy water rights from landowners. So they're not trying to acquire the land; they're just trying to acquire the right of the water that's below the land. And again, it's divisible. You can separate that out from your property. Regarding water in the United States, it really depends on what region you live in. And so they kind of divide it up. They have like eastern states, and then there are western states. The eastern states, so like, kind of like Mississippi going east, they refer to it as a riparian approach. And then so what that essentially means is that for land containing water flow, reasonable use is balanced for upstream and downstream usages. The theory is that, if you have all these property owners living along a river, um, you know, the back east approach is, we don't want someone upstream to divert all the water away, and then so the river dries up. Western states adopt more of a prior appropriation approach. And here, this is what this is referred to as like a first and right standard, meaning that the first party to use the water for some beneficial purpose has superior rights to subsequent parties. Uh, the only kind of limitation on that is that it cannot be wasteful, so it has to be for a specific, kind of like proper use. In terms of easements, that's the right to have some sort of usage with regard to access to the land of other parties. So you're not the owner, but you have maybe some sort of legal claim to be able to kind of use or have access to property. So, there's an affirmative type easement, so that's the right to use the land of another. So maybe you're crossing the land to get access to maybe your property, or to water, or to some purpose of why you're doing it. There's something called a negative easement, and that prohibits landowners from using land in ways that would affect the holder of the easement. So I think the example I give there are solar panels, that owners have that bar neighbors from building structures that block the sun. So you know, if your neighbor wanted to build a 2 or 3 story, you know, kind of structure, and you have solar panels, you know, through this idea of a negative easement, you could prevent them from doing that because it could block, you know, sun and the ability of your solar panels to do what they do. There's also referred to as easements, appurtenant, and then easements in gross. The appurtenant ones, this is where it benefits the owner of the adjacent property. So there's like a dominant tenement and then a servient tenement, the burden land. And the classic example there is a landlocked property. And I think I have a slide here where you know, we try and avoid this to the extent that's possible, but you know, there are cases where in some areas, and this is again, this is usually in more rural areas, where there's property that's technically landlocked, meaning that there's not a direct road access to the titled property, and the only way to get to it is if, you know, you helicoptered in, or if you actually had an easement to cross over an adjacent property owner's land to get to your property. And so that's that easement appurtenant. Easements in gross, that's just an independent right, and the holder doesn't have to be even a landowner there. So, you know, there's a variety of different types of categories of easements, but just kind of know in a general sense, that's the ability to use someone else's land for your benefit. Licenses are a little different because it's a privilege to use land for a specific reason, and it is revocable. Sometimes easements, they're called, like, they will, what is referred to as run with the land. And so, you know, it could be a burden on future owners of the property. Whereas licenses, you know, if you decide, you know, you wake up tomorrow and you're like, well, I really don't like this license arrangement, I'm going to terminate this, you know, as per, you know, whatever the agreement provides for. That's how you kind of maybe distinguish a license versus some of these easements that we've talked about. In terms of categories of land use, so, you know, when you think of like restriction on the use of land through tort law, so again, you know, I mentioned before this idea of like nuisance. You know, nuisance is a collective term that refers to any type of interference with the use and enjoyment of your land. So it could involve noise, it could involve pollution, it could involve odors. And so normally, you know, you have a right to be kind of like, you know, protected from nuisances that can impact your property. But again, you know, understand that, you know, if you're coming to the nuisance, so if the nuisance already existed, that could limit your remedies. It really is contingent on that particular situation. Trespass, that's obviously a wrongful invasion or entry onto the land of someone else. So, you know, again, you know, these are things that, you know, that tort law will provide you protections for. Trespass, as you all probably know or you can surmise, there's also criminal aspects of that. So, you know, we're just discussing the tort aspect of it here, but, you know, obviously there's a criminal aspect to trespass that as it occurs. In terms of owner liability for those that are injured on their property, trespassers, usually there's no duty unless there is a known hazard. Then the standard is what's referred to as reasonable care. You know, so if you know, you have you know, something, I think the next point is like the attractive nuisance. So if you have something that you know could attract others, whether they're children or even other adults, normally, you know, it's like, you know, you've got this affirmative duty to try and warn or prevent of dangers. And it could be something as simple as, you know, a warning sign, or it could actually involve some type of fencing or taking corrective measures to fix whatever that potential hazard is. With regard to licensees, so this, think of like a social setting, you know, so you allow people to kind of come onto your property, into your home, through the holidays, you know, like, you know, when they occur, you know, or special occasions when you have people over at your, you know, let's say your house. Normally, its liability is kind of like, it's like known trespassers. You know, you have that reasonable care standard that we discussed. If it's an invitee, this is more of a business setting. So, you know, you have a commercial, you know, business, and you're allowing people in the public to come into your, whatever your business is, your store, whatever it is. Normally, liability is for both known and unknown dangers in that case. So, there is a burden that landowners do have when others are coming onto their property, whether it's for permission or if it's, even if it's without permission, if there's some sort of attractive nuisance that is kind of pulling people onto your land. Private regulation by agreement. So these usually involve restrictive covenants, and that phrase "run with the land." So that's something that could potentially bind future owners. It is subject to equal protection standards, and so if you recall when we talked about the U.S. Constitution in Business Law 1, under the 14th Amendment to the U.S. Constitution, there's language about equal protection of the laws. And so, if there is some aspect of the land that is, in the past maybe was something that, transferred to future or subsequent landowners, it cannot be discriminatory in practice. So you cannot have in your deed, that would bind future owners. You cannot sell this property to a woman or to someone of a different race or religion, because obviously that would be violations of different aspects of the Equal Protection Clause of the 14th Amendment. So normally what happens, and most deeds have been kind of cleaned of that type of language, although you still kind of hear about it from time to time, but if it does pop up in a particular lease, clearly that's not enforceable, because we're not going to permit through the transfer of land such discriminatory practices. In terms of public ownership or regulation through eminent domain and zoning, so eminent domain is this idea that government can take your property, and it can either be an actual taking where they're literally taking the title from you, or it could be constructive in that maybe what the regulation is, the impact of the regulation pretty much necessitates that your property is unusable for some reason. So both situations could arise with eminent domain. The critical thing, if eminent domain occurs, is that government at any level, because eminent domain could apply to the federal government, state government, or local government, they have to give you what is referred to as just compensation. That's the language in the Fifth Amendment to the Constitution. And what that means, the translation, is fair market value. So that's appraisal. So, if there's, let's say, the 408, the toll road that we have that kind of goes through Central Florida. If they decide they want to expand it, it's like they're going to work with the state of Florida and the different counties that they operate in. If they want to expand the road, they can actually, secure property. And normally how that's going to work is they notify the owners and they say, look, this is happening. Government is going to be taking your property. And then, and then it becomes a battle of, the appraisers. You may not agree with what the government's appraisers say your property is worth. And so you can challenge that's reasonable. But normally if government is set on taking your property, usually that you can try and challenge that, but that usually does not end up successful. The other aspect of public kind of like regulation of property involves zoning. And most places around the United States, we've done a very good job through, like land development and urban planning to kind of map out, what state and local government would like to see land be used for. So, again, think of, our Central Florida community. There are regions, let's say in downtown Orlando, that are pretty much are dedicated exclusively for commercial use. There are parts of, Orlando, South Orlando, and other areas where it's maybe dedicated for industrial use. We certainly see a lot of residential neighborhoods, in Orlando as well as in the surrounding suburban communities. And so, whether it's single home type residential use, or maybe it's multi, kind of like, when you think of like townhomes or condominiums, more high-rise residential structures, all of that is controlled and regulated through the zoning process. So variance can be sought if you want to have like an exception and have some sort of use that deviates from the overall kind of like planned zoning map that every county and state engages in. But that's obviously up to the discretion of the zoning board if you're trying to seek some sort of exception. And you know, again, it kind of it tries to fit in with, you know, the overall management. You know, we don't want to have a factory next to a house, next to a shopping mall, you know, next to, you know, a farm. You know, we like to have more kind of smooth transitions so that we can kind of collectively bundle, you know, different types of use. So if there's industrial activity, let's kind of all put that together, because, you know, there's going to be some nuisance associated with that. If it's going to be a residential community, let's bundle those residential communities together, and so on. So that's part of an overall plan. The last slide that I have here, this is just kind of like a continuation of eminent domain. Uh, for forever, you know, until the early 2000s, the idea of eminent domain, so government taking property from private landowners, the idea behind that was that it was for a public good. So, you know, you may have hated the idea that they took my property, but maybe they're building a school there, or a park, or they're expanding a highway. You know, so it was clear that it was to benefit the public. That always was kind of like the gold standard with regard to eminent domain. In the early 2000s, there was a town in Connecticut called New London, and what they did was they took several city blocks of residential homes. They, through eminent domain, you know, they compensated every landowner. They bulldozed all the homes, so they kind of just cleared out all that land, and so it just became raw land. And the landowners who were displaced found out later that the city was going to transfer that land to a private developer. And the reason why the city decided to do this was that the development that was going to be, you know, kind of that was in the works, or that was being planned, was going to produce higher tax revenues. You know, land is taxed, when you think of like property taxes, you know, based on different types of use. And so, like, residential or agricultural usually gets taxed the least. And then if you start to, you know, have other types of use, commercial use, industrial use, you know, and the other different categories we've talked about, you can actually get higher, you know, a return for property taxes depending on the type of use of property. Anyway, so obviously there were a lot of residents that were upset about that. You know, they thought that what the city was going to do was going to kind of provide, you know, some sort of like benefit to the general public by taking all their homes. And when in reality, they took homes from a private, you know, from private individuals, and the intent was to transfer it to another private developer. And so they sued. They felt that that was a violation of the Fifth Amendment because it wasn't a public good. That was, you know, the entire purpose of the eminent domain. This case went all the way to the Supreme Court. It was Kelo versus City of New London. And, you know, it was a very controversial decision for the time, but the Supreme Court said that the city was entitled to broadly interpret what is good for the public, so that if it's a school, a road, a park, that's what we've always defined as a public good. But in the city of New London, the fact that they would get greater tax revenues, that also provided a public good for that community. And so they said that in this case, this was acceptable. They did provide a roadmap, if you could amend a state constitution to allow, or I shouldn't say allow, to prevent, you know, local governments from engaging in this activity. So they did provide some context there, and they said, you know, if you want to, you know, going forward, because they knew this was going to be a controversial decision, they said that, you know, states can amend their constitutions, and that would prevent local government from being able to do this. So that if they were going to exercise their power of eminent domain, which they still have, it would have to be just for the traditional, you know, public park, you know, roads, schools, universities, that kind of thing. And a majority of states, since the Kelo versus City of New London case, a majority of states have enacted such changes to their state constitutions. Florida has as well. You know, and you know, again, it's very personal. You know, I know in the case of the City of New London, you know, some of the homeowners had their homes there for multi generations, and so there was an emotional aspect to the land as well. Normally that's not compensable, you know, so the city's not going to say, well, okay, you've had this home for, you know, 50 years in your family, so we're going to give you extra money. That's not part of, you know, the appraisal process of land. So you know, when they found out that, you know, in Connecticut, the fact that this property was going to be transferred to a private developer, it really, you know, it hurt a lot of people deeply because of, you know, they felt they were betrayed. It's one thing if it's going to be, you know, again, your traditional use, but to just say you're going to take my property and sell it to another private entity, that just seems to kind of go to this notion of it being inherently unfair. So anyway, I hope this has kind of cleared up some aspects of real property. If you do have any other questions, please feel free to reach out to me anytime. Call, text, email, whatever is easier. But I hope each of you have a good, safe, and productive week. Thank you so much.